Right. Good afternoon, everyone here. Hope everyone is doing well and keeping safe. Welcome to the lecture series being organized by the Center for Public Interest Law. Here we are with our main speaker, Lubhyathi Rangarajan. She's a lawyer and researcher who has conceptualized the Sedition Database work with Article 14. And today's lecture is being organized in collaboration with Article 14. She is also a founding member of Project 39A, which is the legal research and pro bono litigation based center based out of National Law University, Delhi. Lubhyathi has worked extensively with the Ministry of Tribal Affairs, Government of India, the Lawyers Collective Initiative, and her areas of interest include criminal law and the legal process. Thank you so much, Lubhyathi, for joining us today. We have with us as our discussant for the day, Professor Balu G. Nair, who's an assistant professor at JGLS. Thank you so much, Professor, for joining us. And whenever the two of you are ready, we can begin.
Yes, I think thanks for the introduction, and welcome to everyone who has joined in right now. So first of all, Lubhyathi, huge congratulations to both you and your team for undertaking this extremely timely project. I think many of us have been talking about the democratic decay, the democratic backsliding in India for the last few years. But most of these discussions have really centered on anecdotal evidence. At best, people have referred to, say, the VDM index, but I think this is one of the first projects to really put the numbers or put the data behind the claims that a lot of scholars, for instance, have been making. So other than the data itself, which is a huge asset for everyone, I think at least from reading some of the initial pieces put out by Article 14 and your collaborators, what I felt is as equally important as the database is how investigative journalists, for instance, have used the database as a launching pad to bring out the human stories behind these statistics, the human sufferings which actually make up these numbers really. And also another main takeaway for me was that this project has resonance beyond merely sedition law. The way your team has been able to sort of penetrate the opaque, sort of fortified walls that the public institutions generally build and actually cull out this data, I think has resonance beyond just sedition law for people who work in public law generally and public issues relating to public administration. So those are my takeaways. So I want to just start off by asking you, what were the motivations for starting the project? What are your short-term goals and what is your long-term vision?
Thanks, Balu, for starting it with such a broad range of questions. And thanks for having me here. So I would say that the inspiration for this project was certainly, it didn't start with an empirical inquiry. So while that is one of the things we're very interested in, but the inquiry into this was certainly more qualitative and contextual. So part of the reason why we were able to perhaps, uncover such a large data set along so many variables was precisely because, we thought that the conversation should not be dictated only by how many cases are filed every year, while that is a very important question, but to frame it in a much larger sense of the context, the backstory of sedition cases, the political and the social backstory of sedition cases, and not only when they are filed and, but also why they are filed, by whom are they filed, where are they filed, when are they filed. So I think all of these questions are part of, why the kind, we were able to come out with the kind of data we did. The other sort of interesting findings we've come out with, or we'd like to come out with, are around also, of course, the legal process and how the courts deal with these kinds of cases. So in terms of course, the short term, and I think one of the things that you pointed out that was that I'm glad you pointed out was that this is not only about sedition law, and you're absolutely right. In fact, one of the things we found was Along with sedition, of course, a lot of other charges are now placed on people. So it is not only 124A, Section 124A of the IPC. Several other laws are sort of added on. And some of these other laws we're seeing more and more of are, of course, the UAPA. We are also seeing Section 153A, 153B, 295A. These sound like just numbers, of course, to, sort of innocuous numbers, but they're not. In fact, all of these laws in the IPC, the ones that I mentioned, have something in common with sedition, which is that they're all vague and don't have definitions, and they are sort of there, can be used against people who outrage feelings of a class. So this is, this idea of criminalizing sentiment and feelings, which is also what sedition does. Also therefore makes our database sort of, which is why we had the inquiry that we had, which is to really build a foundation to do this kind of research work along all sorts of variables, including, as I said, the backstory of a sedition case, why these cases are filed, which governments file them, against whom they file them. So, but of course, as you pointed out, one of the findings, and the major findings certainly, has been that the number of sedition cases has risen dramatically after 2014. And certainly after 2017 in Uttar Pradesh. So there is unfortunately that kind of political climate that we're seeing, and that's demonstrated by the increase in the number of sedition cases. But I think it's also very important for us to know that this is not also a partisan issue. And one of the things that we discovered, and therefore we chose a decade in our study. So we chose to start with 2010, which was about 1 year into the UPA government. But it's very interesting, the kinds of sedition cases between 2010 and 2014, which is a very different context. And I think the UPA too had a different definition of who a traitor might or might not be. So, it's very important, therefore, to place sedition in that political context. It is certainly not a law that has been applied neutrally. The language of sedition does not allow for that kind of neutral or objective interpretation.
Right. Uh, thanks for the that overview of the project, Lubhyathi. So I'll sort of take on from the last point you made. So something which struck me also, because the project has used 10 years, the last 10 years data. So I was wondering that perhaps the reason why the average number of cases was on the lower side in the first 3 years that you have looked at, which was UPA on its way out, could have been because this is a government which has already served 2 terms. It's on its way out. So, they want to make sure their electoral prospects aren't really ruined. And then you have a new NDA government sort of coming into power with a super majority, and they would sort of go about their business in a fairly high-handed way, as you may expect. So I think, of course, the database allows for that kind of critical analysis of these numbers, which kind of takes me to the second part of my observation slash question, which is that is there a specific reason why you selected these 10 years? Because we all know that sedition as a political law, as a tool, has been used since the time it has come into the statute books. So is there a reason that you've limited it to 10 years? Is it because of the availability of data, for instance? And also, the breadth of the project is something which has really sort of surprised me, because we have kind of managed to map almost the entire of India. And you yourself, in some of the pieces, point out how difficult it is to sort of make sure that this data is accurate, because some of the police department websites, for instance, are completely unreliable. So do you have a fail-safe mechanism through which you make sure that the data you have is sort of foolproof? How do you go about doing that? So just sort of, you can tell us your methodology and walk us through how you arrive at the numbers you do. That will be very helpful.
Right. So yes, I mean, in terms of methodology, which is really what underpins all of our findings. So we started first with, doing a really exhaustive search from media reports. And so one is that all of this was done online. So everything that we got was through, before we sort of sent journalists out to investigate the stories on the field, to build the sort of back end of all of the data. All of that was done online and mostly through open access sources. So we looked extensively at media coverage of all major national papers in English, as well as a lot of other languages, so Tamil and Hindi, Punjabi, Bengali. So whatever, again, in those languages, whatever papers or media outlets were available had online versions, is what we looked at. And we had certain, of course, what you call keywords that we'd input into these websites. And luckily for us, fortunately, or perhaps, not a coincidence, but it's a choice, that because you wanted to look for a particular law, we had a certain keyword already in mind. So it isn't that we were sort of searching the universe and then trying to get very random pieces of data. So we knew what we were looking for. So we did an extensive media search of sedition cases across from 2010. We also then looked at eCourts, which is another open access website where this is a judiciary sort of initiative, the eCourts initiative. And eCourts has been extremely good. While the interface of eCourts is quite, it's not instinctive, especially in the era of paid subscription like SEC Online and Manupatra, which also we used. But eCourts certainly lacks the an extremely sophisticated interface that many law schools are used to. But it's a very good resource to get things like case statuses, court orders, all of that, like this sort of what stage a case is at, for example. And if you're able to use it effectively, and I think we were able to use it effectively, we found a lot of information from eCourts. But this again, we did manually. So we manually had to extract data from every district court and in India. And as you can imagine, there are about uh, there are about 750 districts, but we had to do that manually. So eCourts was another incredible resource, especially when it came to trial courts, right? Because a lot of these cases, and this is the other thing, I mean, the other sort of interesting thing we discovered, and of course, most criminal litigating lawyers will tell you this, is that any FIR that the police files, right, in any criminal case, must be forwarded to the nearest magistrate's court. Now, the magistrate's court, because of eCourts, is bound to sort of upload that on the eCourts website, which they actually do. So trial courts have been quite adept at using, the digital source. So in this way, we were able to dig out things like FIR numbers, the names of parties, the status of these cases, and so on, as well as the district in which all of this happens. We also did an extensive manual search on Indian Qanun, which is again, an open access legal source. And there we were able to source several bail orders from high courts, which otherwise, we wouldn't have found through the media. Because the interesting thing actually about, and this is a deliberate choice again, we didn't stick to one source. If we had done only media search, only a media search, I think the findings would have been very limited. The findings perhaps would have lacked that richness, and as you say, may not have been as accurate or fail safe. The fact that we have about 5 or 6 different sources is also what allowed us to sort of check against each source. And this actually is possible with some effort. It's possible to actually find details of cases on some or the other kind of online platform. Another source we used, I think you mentioned, was a state police department website. Now, this is again, the so police is a state subject, so every state has its own unique police department website with its own unique interface. Now, again, these interfaces are certainly technologically challenging. They're not convenient. There is a lot of trial and error we had to do. There were days that the website didn't work. There were, things that were not downloadable. But despite that, we managed to source about 150 first information reports. Again, first information reports are actually public documents, so there's a Supreme Court order that says that, and for the audience, this might be interesting. It's a judgment called Youth Bar Association versus Union of India, and according to this judgment, all FIRs are publicly available document. They have to be uploaded by the police. But again, there's an exception, as there always is. The police can classify certain cases as sensitive, and in fact, in some of our cases, they were classified sensitive. A lot of sedition cases have been classified sensitive by the police, so the FIR is not available for public viewing. And then finally, of course, we did, a search on paid subscription platforms like SCC Online and Manupatra. But when you're talking about a sort of, method, so I think one was just to manually extract data from each of these sources, which, took us a few months, then sort of put it all together and cross check them against the other and try and find out as much information as we could about cases was another sort of took us another few months. So the combination again of all of these open access sources is what allowed us to build that foundation across the country. We also didn't limit ourselves geographically. So it isn't that, we said we're only going to look at one state or two states, because it seemed like this is something that's possible to do across the country. And in terms of what we did then with the data was, of course, to analyze it along several kinds of variables. So as I said, the purpose of the data was not only to say, okay, how many cases are filed each year, and sort of come up with those trends of, an increase after 2014 or, certain numbers that are less before 2014. But we also analyze the data along several parameters like the occupations of people, their religion, the state government at the time that the FIR was filed, the central government at the time it was filed. And I think all of this, of course, was something we were interested, that was the initial inquiry into these cases. The inquiry was not only legal in nature. So, so this was a sort of method we used. And in terms of, sending investigative reporters to the field, that was this was a new experience even for us, So when we sort of did the Karnataka series of, which is, I would urge everyone to read that. It's a 3-part series that we did of about 30 people who were arrested on sedition in Karnataka. And, this was in collaboration with an investigative journalist, Mohit Rao, who was extremely good. And he actually managed to track down everyone accused in those cases based on our foundational level data. And he was able to speak to them. And of course, we see that reflected in the story, and we can sort of discuss that as well, just in terms of the stories we've been hearing from people and what's happened to them after the case was filed. So, I think this also was something new that we tried. I'm not sure that it has been done before, but I think it also showed us the sort of, the power of at least being able to use a very rich data set, but also not confine ourselves only to that and say that, okay, we can investigate this further with an investigative reporter. So I think that was sort of the first time we realized that this is something that's possible. Yeah, I think I sort of answered. I'm not sure whether you had the next question, but you can just remind me.
You did cover most of what I wanted to know from, and I'm sure that we will have others who may want to ask further questions on the exact nitty-gritties of the methodology, which again sort of takes me back. I think already Bhavani has shared some of the links. We can share all the links at the end of today's session, and there is already a piece which outlines some of the major findings that you have so far. We'll definitely share it with everyone who may not have had a chance to look at it. So one question I was curious about is whether the raw data will be at any point of time, or the database as it is be made available to the public A, that, and B, would it be possible for the general public or whoever is interested to sort of collaborate and send in the data that they may have, which you otherwise may have missed out, for instance? So, what is the kind of public interface that you're looking at right now?
Right. So, thanks for asking that question. Yes, we are actually looking to have this, all of this data not as a raw database, but certainly as a more interactive website that we're actually currently working towards. And we hope to have that out as soon as possible in the next 2 months or so, 2 or 3 months. And yes, there's definitely a chance for people to to collaborate with people who have information about sedition cases, because this is the other thing about data collection, or doing data work in India. And I think earlier you'd alluded to the opacity of public institutions, and the fact that the unwillingness, of course, to open up to researchers or people who don't perhaps have the resources to go through universities or other spaces. And I think it- what we realize, I mean, the opacity, of course, is a very separate question, especially when it comes to sedition cases. But the other sort of interesting thing is how much data, even when Mohit went to Karnataka, he actually discovered more cases that were filed, none of which are reported, none of which we found online, or that were uploaded at the time we were doing our data collection and extraction. So it's entirely possible that when you do the field work, and this is again why perhaps we were able to discover so much, is that it is not just an inquiry we're doing only from open access sources, but the combination of having to do this, of doing this with investigative journalism, is also what gives it that kind of you're able to see the reality of it. And the reality is there is a lot we don't know still, and there's a lot we still have to discover. I mean, and by we, I mean, of course, the sedition work itself. Because even in the early years between 2010 and 2014, again, it seems like it was a really long time ago, under the UPA too. But at the time there was a very different sort of narrative that was being pushed by the central government, one of economic development, and sort of Manmohan Singh's statement around left wing extremism at the time, and that it is India's biggest internal security threat. And it's really interesting, and I'm not trying to say that there's an absolute correlation here, or that we've sort of, but there is a sort of between, in those 4 years, you see a lot of cases in Chhattisgarh, Jharkhand, and Bihar. Specifically in certain geographies, there are a lot of sedition cases filed between 2010 and 2014. So it's impossible to sort of isolate the law from what's going on politically, and from the kinds of statements made, and they're just statements. They may not be specific policies, they may not even be specific laws. Often they may just be statements coming from the at the highest level of the government, public statements made. And then you sort of see these a surge in a certain type of case, right? So this is something that we saw, but a lot of those cases, again, between 2010 and 2014, are cases that are still sort of things we have to discover. And that's something we, only if we're able to meet the people accused in those cases, we'll know much more about them than we currently do. So I would say the long term plan, and I think that's that's another question you had. The long term plan, or rather the long term sort of goals of this research, is one, not to say that it is only about sedition. The goal is certainly to discover more about what we already know, discover what we what might happen in other laws as well, such as 153A, and sort of and this brings us, of course, to the inevitable question of the constitutionality of sedition is sort of hanging in the balance through statements of the Supreme Court, and whether we should all heave a sigh of relief if there is some sort of repeal of the law. And I think in our data, what we're seeing is that sadly we can't breathe that sigh of relief, because sedition is only a symbol of several other kinds of things that are going on, and several other kinds of laws are still being used along with sedition. to kind of implicate people. And something else that perhaps I'd like to just bring up is this perception. So often when we were having so many internal conversations about what we found, and even after we put out our story, a lot of the feedback we were getting was we didn't know that there were so many kinds of people against whom the law is being used, because there's a perception that it is only academics or intellectuals or certain outspoken critics. There's certain kind of person, journalists, right? So there's certain kind of person you think that the law seeks to target. But what we've discovered is that that is not the that is absolutely not the case. And again, the Karnataka story was a great example of that, in terms of demolishing that perception of only these people are targeted for sedition and no one else is. I mean, the range of occupations we're seeing in terms of informal sector workers, for example, just daily wage laborers, coolies, electricians, a teacher, a plumber, and none of the students, 18, 19-year-old students, who are not sort of, again, part of the, universities that tend to be in the news cycle, but just, students, the rural poor, for instance. So this is something that we, discovered in that, in the process of building all of this data. So a lot of our own perceptions were challenged when we were doing this work. And of course, part of it is also the kind of media coverage that we saw in sedition cases. That where there's an intense scrutiny of certain kinds of sedition cases, and those cases are reported over and over again. Even the legal process in those cases, there's a live tweeting of the bail proceedings. Nobody else, for instance, the chicken shop owner in a district in Karnataka didn't have the quote unquote advantage of a live tweeting of his bail rejection, right? So a part of the I would say this very skewed kind of media coverage of sedition also contributes to that perception that it is only academics or intellectuals or journalists who get affected by the law. And I don't think we quite realize the extent to which all kinds of people are being targeted under this law.
Right, and I think the three-part series is the best sort of source for everyone to go back and read to fully understand what you have been trying to hint at. Absolutely innocent mistakes, people sharing things on social media without even realizing what they had shared, and these innocent mistakes leading to their livelihoods being destroyed, they spending so much time behind the bars. So yeah, the great point that you made, that it sort of demolishes some of the preconceptions we may have in relation to who the law is applied against, which kind of brings me to the larger discussion surrounding sedition law. You already mentioned how the Supreme Court has sort of seized off the matter and may sort of take it up sometime soon. Now we know that it has had a very sedition law has had a checkered history, be it at the level of the High Courts or the Supreme Court. Initially, post independence, there were some of the High Courts which read it down or read it in a very narrow sense. But then, so say, there were other set of cases which looked at it in a very broad way. And even Kedarnath Singh judgment, which we all sort of refer to as a laudatory decision at some level, the fact remains that the test laid down there also is fairly vague, right? I mean, incitement to violence, at least to my mind, uh, without actual violence taking place, how do you establish whether there was an incitement to violence, for instance? And the fact that the reference is to incitement to violence, that makes it easy for it to come within the scope of 19.2, the public order reasonable restriction. So, I mean, we are right now, of course, clutching at straws here, and we at least want, say, the Kedarnath standard to be applied when absolutely, uh, you know, straightforward statements are being held or being charged as seditious. We at least hope that the Kedarnath standard is upheld, right? So in case they say, the court doesn't strike it down, we all hope that it does strike it down. What do you think could be the way in which the court could perhaps read it down, or what do you think could be the safeguards which can in some way be initiated to make sure at least the law isn't misused or abused the way it is done right now?
Balu, I think maybe before we get into the Kedarnath Singh question, again, what the substantive question of incitement to violence and whether the court was right in doing so or not. The thing that Kedarnath Singh does not talk about is at what stage is it required, who decides incitement to violence and who is doing that interpretation, leaving aside the question of what the court might or might not do with Kedarnath Singh. But as it stands, I mean, this is the problem with the Constitutional Bench decision first, which is that the executive is under the impression that the courts are going to interpret Kedarnath Singh. It's not their job to interpret. So when the police is filing the FIR, let's say, for example, in one of our cases, somebody was arrested for a Facebook post for saying there are no ventilators. This is, of course, during the pandemic last year. So somebody posted on Facebook saying there are no ventilators here, and this is a bad situation. And this person was arrested for sedition and was in prison for at least more than a month. The High Court then granted them bail and said, why has sedition been imposed? But of course, it's a bail hearing, so the court doesn't get into the merits of that case, right? So all they will do is sort of question the need to add sedition, but they will say, all right, this case has to be decided trial. Now, this is another question, right? So this idea of even incitement to violence that Kedarnath Singh puts on everyone, it's an idea that the police is not interpreting at the time of filing of the FIR. So, in fact, that question is not dealt with at all. And here, in fact, I would say Ramnandan, the Allahabad High Court judgment, which sort of, I think, repealed sedition before Kedarnath Singh, that judgment does a really good job of addressing these questions of interpretation. And the fact that, you're leaving this interpretation at the time of trial, not even at the time of filing of the FIR, not at the time of bail, but at trial, which we all know is a now in this sort of in 2021 takes several years. So finally, the question of did you actually incite violence or not somehow is something that is decided about at least 5 years after the FIR is actually filed against you. So this I think any sort of constitutional interpretation or any constitutional question that the court decides, it sort of I think today has to address this question of when these interpretations happen, because the other thing we found out through our research is that there is a what you might call a log jam of cases at the pre-trial stage where no such constitutional interpretation happens. So the accused who has posted on Facebook about a lack of ventilators, which perhaps to a reasonable person like you and me might not seem at all inciting any kind of violence, no intent or mens rea in terms of inciting violence. But that question is going to be decided at trial, which is a very long process. The starting of the trial and then the entire trial process itself of examination, cross examination, and all of, I mean, etc., etc. So so this sort of I won't even say it's a delay. I would say it's just this strange void, or maybe strange reluctance by different institutions to figure out when are we interpreting Kedarnath Singh, and who is doing that interpretation, and should they be doing it at the time of FIR? Should we be doing it at the time of bail? Because I think what's most pressing here, or again what we have discovered through this work, is this question of time and the cost that people are paying with literally their life, simply because you don't, institutions are reluctant to interpret judgments at the time of filing a case. And so I have to wait about 10 years until I'm finally acquitted or convicted of sedition. So, so that addresses the question of course, when these interpretations take place. And that is a problem with Kedarnath Singh. And Kedarnath Singh itself, and here I would perhaps, bring the audience to the work of Dr. Anushka Singh, who's a professor at Ambedkar University, and she's written extensively about sedition, how and published a book on sedition. She's also recently authored an op-ed about this interpretation of Kedarnath Singh and why it's a problem. And I'll just paraphrase what she's saying, which is that what the court has done really in Kedarnath Singh is converted sedition into a public order offense, which it is not. The language of sedition really is designed to arrest someone's spreading disaffection against a government. Now, is this a public order question? Or which is you have other kinds of laws to address public order. What Kedarnath Singh has done by bringing in incitement to violence is make this idea of sedition or deshdroh or criticism of the government into something that is public order, a public order question. So that is something that is certainly the problem with Kedarnath Singh. And I think as to what I think your third point on whether there are safeguards or whether they can be safeguards, I don't think there can be safeguards, and so I think after having done this done this research and sort of examined these questions, I think you sort of conclude that it's it's impossible really to have safeguards for something like sedition, or to have a committee that will evaluate whether or not a case is filed, or a committee that will evaluate whether bail should be granted, or setting up other administrative or quasi judicial mechanisms to safeguard the use of sedition doesn't will accomplish what would it accomplish really? I mean, if the provision is designed to be used in a certain way, uh, safeguards, I'm not quite sure. I mean, my imagination on safeguards for sedition is certainly driven by the fact that I don't think there can be safeguards for sedition. So I think that yeah, so I would say that it's impossible. It's a very loaded political question at the heart of it, and therefore, can there be safeguards? And you know what, there are actually existing safeguards, right? I mean, in terms of Kedarnath Singh is a safeguard, isn't it? The fact that the court has diluted the provision is a safeguard. They've said, look, you can't use sedition in every case. You can only use it in incitement to violence. But that's clearly not happening, right? I mean, clearly there are more cases being filed against extremely non-violent sort of expressions. So, so what is the point? And this is a nearly 60-year-old judgment. So in 60 years, clearly it's made no difference, the fact that the court has read down the provision. There's another safeguard in the words of section 124A itself, which is criticism of the government is not seditious. I mean, I'm paraphrasing again, but that's essentially what section 124A says. This is a safeguard that exists in the Bare Act, which every police officer has a copy of in every language. So, so what more really do we need in terms of the law being fairly clear of when sedition can be used or not? So these safeguards already sort of are built into, in the system in various ways. So, any more safeguards, I'm not quite sure whether that would work.
Right. I mean, the classic case of now who is going to police the police, or who is going to look after the committees which you set up for these purposes. Absolutely. Yeah. The other interesting thing I picked up from the pieces that are already out was this emergence of private complainants. I mean, this is, uh, of course, crime against the state, so you would expect the state to be the complainant in most cases, but you see that there are a number of people, like private individuals, are doing this. And is this something as a result of the spread of social media? Have you sort of observed any trends insofar as there are more and more private complaints happening in relation to sedition cases?
Yes, I mean, we're going to again come out with, in fact, a story on that, and where so all of that data, yes, we're sort of processing, and we'll certainly come out with robust findings on that. But yes, we are seeing an emergence of private persons or individuals who are not part of the investigating agency, but who are affiliated to other kinds of, either political or, other kinds of social groups that are filing sedition cases, or rather filing complaints to the police and saying sedition case should be lodged against so and so. And I think social media has certainly a large part to play. In fact, certainly you're seeing from political parties or handles or certain Twitter handles that might tag the police and say, you need to file a complaint against so and so. And the police has acted and filed FIRs on the basis of these sort of complaints. So yes, there is a rise in these kinds of complainants, which also makes me very wary of this idea of safeguards, because again in Karnataka, and this is a classic example of hyper local politics uh, playing out in the filing of sedition cases, and people belonging to local parties who sort of can pressure the police into filing a case. This is something that we saw in Karnataka. And in one particular case against six men who posted on social media, seemingly in sort of, you might say, almost at the same time. And, we saw there all these six men had identical bail orders, barring the sort of cause title, their names. But all their bail orders, which bail was rejected to them, but all the bail orders were identical. And when we first read the bail orders, we thought maybe they're part of a group or some sort of WhatsApp group. They were all accused of posting, something on Facebook. So we thought maybe they're part of a Facebook group together and knew each other. And it's only after Mohit, who's the journalist, went and interviewed them, they told him how they all met in jail for the first time. And these were all isolated incidents on Facebook. Somebody who saw the Facebook post complained to the police saying they have put something offensive on Facebook. So, this kind of story we're seeing certainly more and more of. There is social media surveillance of everyone's sort of, phones. We're also seeing people, in, I would say, rural social media users, if I may use that term, or people who are not very comfortable with English, and who sort of click on something without realizing what they are doing. And we saw that in this case of the six men, none of them knew what they were clicking on, and sort of thought that the words meant something when they actually meant something else. And so, and of course, that sort of interaction they have with social media is then something that someone else complains to the police about. Because hyper locally, we're also seeing, especially in this series, we discovered people are on several WhatsApp groups locally. And so if you post something on a WhatsApp group, anybody on that group can complain to the police and a case is filed. Now, the question is, yes, someone can certainly approach the police with a complaint. Is the police obligated to file an FIR? I mean, that's the next question, right? So while there is a rise in the number of people complaining to the police, the police still has a choice not to do it based on the reading of the law. But yes, we're seeing that happen more and more, and we're certainly going to come out with stories on that point. Yeah.
Right, that sort of indifference on the side part of police officers also captured in one of the pieces where the police sort of throws their hand up in the air and say, look, this is our role, we don't need to make that determination. It is up to the courts to finally try and adjudicate whether this actually amounts to sedition. So it ties in well with your earlier point of where exactly do you determine whether there was an incitement to violence, etc. So I think definitely, there needs to be a change at that level, or perhaps more awareness as to whether they should actually be filing these really frivolous cases. I think we are approaching towards 4:45, and I want to leave at least 15 minutes for those of you who may want to ask a few questions. So I will ask you one last question, which you already mentioned in the course of our talk discussion right now, which is that definitely sedition is just a symptom and not the disease itself. And you talked about how in your study itself there are findings of how it is being used in combination with, say, section 153A, 153B, UAPA. So even if sedition were to be struck down tomorrow, there is absolutely no guarantee that some other political law is not going to be used against these people, right? Uh, Against all of us, really. So do you also, from your analysis, see this only to be a symptom? Do you then think that the scope of your work will go beyond that, and do you see that happening anytime soon? So yeah, just sort of your way forward, really, and then we can move on to the Q&A.
See, the thing with sedition, of course, and we can't ignore that, is that it is translated. The language of sedition is one of being a traitor. So it's translated as Deshdroh or Deshdroham. It's a label that's very hard to shake off for a lot of people, especially the kinds of people who, as we mentioned, don't have the same social or economic capital that others accused of sedition might have. So the label certainly, and if the law is repealed, it would certainly hopefully remove that, the label that the law seeks to give you in terms of that you are a traitor, which is what sedition is because sedition is translated as Deshdroh or Deshdroham in many languages, in Tamil and Kannada and Hindi and, Punjabi and I think several other Indian languages. So certainly, I mean, we should be happy if that label is at least, no longer exists in the language of the law. But in terms of the fact that other laws can still be used against you, the vagueness of those other laws, which is very similar to sedition in terms of outraging feelings of another religious class or a class of persons, or a group of people, or race or gender, or several other sort of things. So this concept of outraging feelings still exists, and the fact that if you tweet something or say something, you might still have other provisions of the Indian Penal Code that might be, that you might be charged with. So yes, I mean the project or this research work therefore travels through all of these other laws, and in fact that was one of the that was, I would say, the inspiration for this. That sedition is one window for us into ultimately how these laws or the everyday life of these laws really plays out, who is affected by it, who instigates the case, where are these cases filed. And this is as true of sections 153A or B or 295A or 5052 or any other provision in the Indian Penal Code that says you can be arrested for outraging feelings of another group of people. So because the legal process is the same on paper, but certainly how that process plays out for you in terms of how quickly a case is filed and how quickly you will be arrested, how much time you will spend in jail before you're granted bail. Do you have a lawyer? Are you able to afford a lawyer? All of these questions are part of the legal process, which we've already sort of laid the foundation for in our sedition work. So there's definitely scope to expand this beyond the borders of only sedition. Yes.
So thanks, Lubhyathi. I think I will sort of wrap up my set of questions at least for now. And Ankita already has sent in a query here. Uh, and her question is there a class caste pattern visible in the sedition cases data? Very pertinent question.
Right. So caste, we were not able to find out caste for every one of the accused. Again, that is something we can only get from our field work, because caste is not something that is easily determinable only by name. But yes, I mean, what we have seen in Karnataka and what we are seeing now in UP, there is a pattern of of Muslims and of lower castes being uh, perhaps affected by the law, but to be able to give you a national picture of it will take much longer. But in terms of, again, it's an interesting question about class, really, because you know, there are there are people, journalists who you might consider to be, not the local journalists, but sort of journalists who are well known, politicians who are well known, who are all targeted under sedition as well. The thing that class does when it comes to sedition is that you are able to afford a lawyer who can perhaps petition the Supreme Court directly. That's what class does. So I wouldn't say class is a guarantee that the case won't be filed against you. I mean, there are no guarantees, of course. But for example, and I'm using this only as an example here. Say someone like Vinod Dua or say Shashi Tharoor and Rajiv Sardesai, and there were a whole bunch of journalists who against whom sedition FIRs were filed after the farmers' protest. Of course, now none of them were arrested. They had the case filed against them, but they were not arrested. They were also able to petition the Supreme Court directly. This is sadly a luxury for a lot of people. So I would say that, and this is true of other people as well, in who we found in our research. And typically, you might find that politicians also have some access to legal resources. They have some lawyer at least who can petition the court. So I wouldn't say that class sort of isolates you, unfortunately, but it gives you certain advantages, like being able to uh, have a lawyer petition the court immediately after an FIR is filed against you. But more numbers on class and caste will be, forthcoming on our website. We're still sort of dealing with those numbers because we still need to finish field work on a lot of our cases. Yeah.
I think if we have further questions, you can just raise your hand using the raise hand function, and perhaps identify yourself and ask the question. So the floor is open. We have around 10 minutes. So Saptarshi has a question. Go ahead.
Hello. I hope I'm audible. Thank you so much for this for the talk. I've learned a lot from reading the articles that came out on Article 14. I wanted to know, are there Indian examples where data has been used as part of litigation and courts have relied on data to strike down laws?
I think immediately what comes to me, I mean, there are examples, immediately I think what comes to me, perhaps 66A, I think is an example of that. I think Shreya Singhal is an example of data being used to strike down laws, but I'm sorry, I'll have to think a little bit more before I come up with more examples. But I think a lot of the public interest litigations, I think, for instance, on the right to food, a lot of that was based on first data collection, extensive sort of data collection on the ground. So there are examples, but I think Saptashi, we may have to get back to you on that. I just have to, think a little bit. I'm not able to come up with something offhand. I think a lot of the I mean, Balu, you can pitch in too. Like, I think a lot of the socio-economic rights that the Supreme Court has decided in, or environmental law, I mean, in a lot of those areas, the right to water or, health and sort of those issues, if I'm not mistaken, were based on data collection. It's just that perhaps that data was not maybe made available in this format, or as a sort of, but I think they were all part of these ongoing litigation. So Balu, I don't know, you can pitch in too.
Yeah, I'll have to sort of look at it. But one thing which suddenly came to my mind was one of these four judges' case. I think it was the second judge's case which talked about the collegium, and one of the judges in it, I can't quickly recall who exactly it was, but goes into the diversity within India's high courts and generally traditionally in the Supreme Court, to sort of talk about how historically, we have not been able to ensure adequate diversity and representation within Indian courts. I mean, the judge was using it as really to inform his opinion. I wouldn't go so far to say that that was really the focal point, or that was used to give the final decision, but that suddenly came to my mind as I recently read it. But definitely, I think we can all go.
I mean, I think so. It just occurred to me that these are, I mean, so in terms of affirmative action, I think Saptashi's question was on striking down laws, but I guess on, of course, on things like affirmative action and, the sort of enforcement of socioeconomic rights, which is a positive obligation. So I think these things are certainly decided on the basis of data. I think his question was on striking down a law. And I think in striking down law, I mean, again, 377 also was a sort of, I mean, if you, I mean, I hesitate to call it data because I think data also gives you a empirical sort of understanding. And I think 377 was certainly based a lot on anecdotal experiences. So that is also, of course, one kind of data. So I think in striking down 377, certainly the court relied on, people's experiences and people's sort of saying what has happened to them. And it gives you a sense of the proportion. So I think that might be one example of the court relying on data and not only on precedent, if that makes sense.
I think we have maybe time for one more question. So in case anyone has any further questions, please feel free to ask now. Yeah, my apologies. I sort of, yeah, I think I did not take into account that the question was directed at striking down of laws. Yes,
No, that's fine. I mean, I think it just, when you were talking, even I realized, okay, that is an interesting question in terms of, enforcing a positive right versus striking down a law and the data approaches to both, or, so yeah, I think.
And also, till the time we wait for another question, I wanted to tell those of you who are students, maybe who have joined in, the book that Lubhyathi was referring to. I think it's called Sedition Liberal Democracies by Anushka.
Yeah.
Professor.
I mean, I would say that she really, she really lays out that landscape. I mean, she looks at it in depth, I think, in 3 or 4 states. So she interviews a lot of farmers and other people in these 3 or 4 states, Delhi, Haryana, and I'm not able to recollect the other two, Punjab, I think. And she sort of makes that inquiry as well, that not only about, the law, but really how it plays out for everyone, what happens to them after the sedition case is filed. So she's it's an incredible book, and I think I would encourage everyone to read it.
Yeah, in fact, I was going to just mention that we do have access to the book, the e-copy of the book, through our remote login facility. It's available on the Oxford Scholarship Online database. So, yes, those of you who are interested perhaps could go back and get access to it. Uh, yeah. So just 2 minutes left on the clock, and if you don't have any further questions, Rupini, if you would like to sort of say anything further, please go ahead.
No, this was really nice. I mean, thank you for having me. I think it's always good to, this is all a legal research in progress. I think what's really good is, I mean, for me personally, I think being trained in the law, you're always taught, and since, there's a law school in Jindal as well, you're always taught about this neutrality and there's an objectivity and, these sort of fundamental values of justice, or justice is sort of, blind. You're supposed to be objective and not subjective. And I think as you're doing work like this, sedition work, you realize it's not true that things are subjective. There are, considerations outside the courtroom that affect, how cases are dealt with, or why cases are filed, or why the law is used. So I think certainly for me, the project and this talk has been very helpful in clarifying those sort of thoughts. And I mean, I'll say this again, but we are coming out with a website on this, and it'll have all of this sort of laid out in a very a user friendly sort of way, and we're trying to make sure that and also that it sort of make sure that it stays it's an academic sort of work. And I think part of what we're trying to say is that it's not only about which political party does what, and this party is good and this party is bad, and I mean, I think we all know that this is a law that really everyone's used. And I think we need, as lawyers, certainly, I think we should remember that, yeah, it's possible to manipulate things, manipulate the law for political purposes.
Thank you so much, Lubhyathi. I had a great time discussing, having a conversation today, and also reading all those pieces. So, really look forward to your further work as well. So, thank you for having me.
Thank you. Yeah, thank you. This was really nice. Thanks. And thanks for everyone for joining in and listening in.
Thank you so much, Lubhyathi and Professor Nair, for this really interesting discussion, because for me, the key takeaway here was that there is also a sort of a legal research that can be done by collection, not just collection of data, but also integrating that with narrative storytelling that you get with the help of your, investigative journalists, and putting that together in this database. I feel this is a really, really fascinating project for me personally, and I really look forward to the database when that is released. We'll wait for it, and I'll also share that with the larger JGU community when it is shared by Article 14. So thank you so much, Lubhyathi, for sharing your work with us that you are working on, and thank you so much, Professor Nair, for initiating this discussion and being with us today. Thanks to all the participants. Thank you, everyone.
Thank you. Thanks, Bhavini, and thanks so much, Balu.